government to go on allocating more funds, sources, and fountains have their source in fountainheads. Strictly describe the role of a judge in our adversarial system. He cannot stay aloof as an umpire and not remain as a neutral referee in a match. The pilots of the plane know his own conclusion, just as a police officer strain on the judges is removed. 98%, mind you, objections pertaining to jurisdiction, court fee, and limitation. Judge can pronounce judgment at once as mandated execution of the promissory note. If the plaintiff's advocate fumbles, the judge can. Similarly, when the plaintiff's advocate cites a ruling of the Honorable Supreme Court on a particular, the judge should initially, suppose this is the balance on that side, they are beating about the bush, deliberately advance lengthy material, both of facts and of law, getting flooded with appeals. Hello everybody, I am G.V. Desai, advocate practicing in Adoni in Kurnool district of Andhra Pradesh. Adoni is a revenue divisional headquarters, but there is also an additional district court here. I have been practicing since 1981 with whatever experience I can claim in the trial court practice. I wish to speak to you about the problem of delays in the administration of justice and how best we can solve this problem. Everybody is in the habit of saying, after all, the number of judges is insufficient. Unless the government sanctions more judges, more courts, the problem will continue. Starting number of courts is a very expensive affair. It is an expensive affair. A few years ago, it was estimated that to run one court in the lower judiciary, the annual cost, recurring cost, would be around 70 lakh rupees. So with such high cost, it's impossible to expect the government to go on allocating more funds. So we have to explore whether it is possible to make the best use of the available resources, I mean to say manpower, to deliver justice quickly. In this chapter, I wish to speak about the procedure to be adopted by judges, especially in the subordinate judiciary, to pronounce judgments quickly with minimum of strain for themselves. Let me now go straight into the subject. Order 20 CPC enjoins that the court shall pronounce judgment at once after hearing the arguments. How is it possible for a judgment to be pronounced at once? Were the lawmakers who made this provision ignorant of the role of the judge? Is it not the duty of the judge to go through the entire record, each and every word in the judgments that are cited by the advocates, as the advocates have a tendency to highlight only a portion of the citation that is favorable to them and hide the unfavorable portion? Is it not the duty of the judge to act like a source of justice? Just as the rivers have their own sources and fountains have their source in fountainheads, the answer is that most modern judicial systems are designed on the adversarial pattern. In this pattern, the judge acts like a neutral referee in a match. A division bench of the Honorable High Court of Andhra Pradesh correctly described the role of a judge in our adversarial system in the following words, open quote, I can blow my judicial whistle when the ball goes out of play, but when the game restarts, I must neither take part in it nor tell the players how to play, unquote. This is a division bench ruling reported in 1992-3 Andhra Law Times 551. The task of an inquisitorial judge in a commission of inquiry is to investigate and discover the truth, whereas the task of a judge in the adversarial process is to merely cross-check whether the hypothesis of the plaintiff or the complainant is tenable in the eyes of law. As Justice Sri Krishna said, a judge should stay aloof like a referee and not snatch the bat and hit a six. Every judge is like an impartial referee or umpire in a match. Just because a judge has a passion for basketball, he cannot apply the rules of basketball while judging the play in a football match, as this would result in the winners being declared as the losers and losers as the winners. The players would have played the match keeping the rules of the football in mind, as per which touching the ball with hands results in penalty points, while in basketball it is the exact opposite. Now let me explain the design of the Indian judiciary. Our judicial system is designed on the adversarial pattern, which is also considered to be the most impartial system. The following provisions show that the system is not inquisitorial but adversarial. 1. Section 101 and 102 of the Evidence Act clearly place the onus of proof on the parties who make their respective allegations. If judges were to act like investigators, the Act would have placed the burden of discovery of truth on the judge. In the Commissions of Inquiry Act, there is no such restriction on the role of the judge because it is for the judge to find out the truth by his active involvement. He cannot stay aloof as an umpire, but at the same time, at the end, he cannot pronounce judgment but only submit a report. Even a judge of the Supreme Court or High Court, when heading a commission of inquiry, cannot pronounce judgment convicting or acquitting anyone. For instance, when there is a plane crash resulting in loss of hundreds of lives, both in the plane and on the land where the plane crash landed, a Supreme Court judge who is appointed as the head of the Commission of Inquiry is expected to act like an investigator and not remain as a neutral referee in a match. The pilots of the plane may accuse the ground crew of negligence, and the latter might blame the pilots. There would also be other theories that on account of mechanical breakdown or sudden gust of crosswind or sabotage by some terrorists, the crash would have occurred. The judge has to investigate into the various versions and come to his own conclusion, just as a police officer just as a police officer does the investigation. Based on the report of the inquiry, the government may or may not act upon it as it is not binding. If it decides to act, prosecution is launched against the persons who are reportedly guilty of negligence as per the report of the Supreme Court judge. Only the magistrates court or the sessions judges court, where these functionaries become only referees and not fresh investigators over and above the investigation report of the Supreme Court judge, can ultimately pronounce judgment either convicting or acquitting the accused. In fact, in all advanced countries, it is the juries that will decide the guilt or innocence of the accused and not the judge alone. The judge only decides questions of law, while the questions of fact are decided by several jurors. Because while deciding facts, the experience of the judge, the mental makeup of the judge, they also count. It will be wrong to put all our eggs in one basket. Similarly, if you entrust all powers only to the judge to decide both the questions of law and questions of fact, it would result in a sort of a tyranny of the judge. That's why the legal profession in India became rather mellowed and lost its ability to fight corruption or whatever it is in the judiciary once the jury system was abolished way back in the 1960s. Next point, now I am only trying to list out why and how I say our system is adversarial and not inquisitorial. The next point is Section 138 of the Evidence Act does not prescribe that the judge should put questions to witnesses. Then, next point is Section 165 of the Evidence Act no doubt empowers the judge to put questions, but various authoritative pronouncements say that the judge must not put questions in an inquisitorial manner. For instance, 1969 MLJ, criminal, page 499. Judge must not descend into the arena. AR 1954, Calcutta 305. Then Laws, Gujarat 1993-4-40. Hasmukh Bhai Chinnu Bhai Shah versus State. In this decision, it was held that in order to maintain its aloofness, even the Lokayukta, which does not conduct adversarial proceedings but is an investigator, also may appoint a counsel for Lokayukta to cross-examine the witnesses in the course of the inquiry instead of doing it itself. Next point, Section 151 CPC, though gives wide discretion, open court, it cannot affect parties' substantial rights. A judicial innovation is not an unbridled horse to be allowed to roam about freely in any direction it likes at its pleasure. This is laid down in a ruling of the Madhya Pradesh High Court reported in AIR 1988, Madhya Pradesh, page 50, notes of cases. The next point. As per the CPC, where the party is a minor or insane, the court appoints a guardian ad litem or a court guardian. The court will not conduct the case on behalf of the disabled person. In the adversarial system, advocates who are also officers of the court take care of the benefits of the inquisitorial process by resorting to discovery and inspection under Order 11 Civil Procedure Code and Order 12 Civil Procedure Code. In his fascinating book, Why Lawsuits Are Good for America, Professor Carl T. Bogus rights. Open quote. Trial lawyers do not have to rely on whatever documents manufacturers turn over a response to written requests. Here, manufacturers mean manufacturers of automobiles. They may summon company employees to testify under oath. This discovery device often shines a light into the otherwise impenetrable darkness of the corporate interior. So, what I would like to say is, it is the advocates who are also unofficial judges, but they are inquisitorial judges. Inquisitorial unofficial judges, because they discover the truth. Their first discovery starts with lawyer's notice. When a client approaches, we are not supposed to file a case straight away. On the basis of the client's instructions, we are supposed to issue a lawyer's notice to the opposite side. Under instructions from my client so and so, I address you as under the facts of the case. Come on, you are called upon to do this or not to do this, failing which legal action will be taken against you. Then the opposite side goes to the lawyer, another lawyer. He is also an inquisitorial unofficial judge. He also applies the law to the facts of the case as narrated to him by his client and comes to a conclusion whether the contents of the notice issued by me are tenable or not tenable. If he feels that they are tenable, he should advise his client, Baba, no point in litigation. You better compromise the matter. If you go to court, you will be the loser. Justice Oliver Wendell Holmes, he had observed nearly a century ago that what is law? Law is a prophecy of what courts would decide. That means it's a prediction of what court would decide. If you know the law, you can predict how the judgment would be. Let me take a simple example. A person is accused of driving on the wrong side of the road. The lawyer knows the law that one should drive only on the left in India. In America, it's the reverse. So the lawyer finds out from the video that his client was driving only on the left side. So he will tell the client, don't worry. In spite of the prosecution, you are bound to succeed. That prosecution is going to fail. That means the judge is going to acquit you. So that is the prediction he makes. Let us take another case. Suppose the same client is actually driving the car on the right side and there is an accident. The lawyer will say, no. Obviously, by applying the law, you have done the wrong thing. This is not America, this is India. So, as per the law of the land, you are guilty and the judge is going to find you guilty. So, better you admit the offense and pay the fine. And in more serious cases, you can resort to plea bargain. In America, 98% of the criminal cases are decided by plea bargain. What it means is, the prosecutor, who is also a lawyer, acts as an unofficial judge before launching the prosecution and decides whether the evidence that the police are going to place is sufficient to convict the accused or not. Then, once the accused goes to the defense lawyer, he also says the same thing. Yes, Baba, as per your instructions and as per the law of the land, you seem to be guilty. No point in contesting the cases. Better you go in for a plea bargain. That's how the cases are decided quickly. Lot of strain on the judges is removed. 98%, mind you. 98% of the cases are decided like this in America. There also, some lawyers challenge the procedure of plea bargain in the Supreme Court there, saying it affects the fundamental right of the accused to contest a case and all that. But the Supreme Court there said nothing doing. If the traditional method of contest in every case is allowed, our justice system is simply going to collapse. Our means their American justice system. We must know, in America, the government allots much more funds to the judiciary than our government is prepared to do. In spite of all that, the legal system there came forward with the procedure of plea bargain. Way back in 1970s, the Supreme Court there upheld that procedure. Now we are nearly 50 years behind them. And though the plea bargain was introduced nearly a decade ago in our CRPC, nobody is bothered. So this is how, and everybody talks about delay, and these Lok Adalats. What is happening in the Lok Adalats? The police are virtually forcing the complainants to compromise. Judges are requesting the police. How absurd it is. Next point. The court must decide the issue raised by the parties and not impose its views. This is laid down in a ruling reported in AIR Supreme Court Weekly 2000, page 794. Court must decide only those points that are raised by the parties. If new points are to be decided, both the parties must be notified as a principle of natural justice. This is laid down in a judgment of the Supreme Court reported in 2003 AIR Supreme Court Weekly, page 4504. Next point. Even the Supreme Court cannot deviate from the law on moral considerations. 2003 Supreme Court Weekly, page 294. Then the next point. Under section 26 subsection 2 of the AP Civil Courts Act, court can decide as per equity only when there is no clear provision of law or rule of interpretation that is in operation. No doubt, the judge can suo motu take objections pertaining to jurisdiction, court fee, and limitation. This is also a part of his role as a referee. As for instance, in a boxing match, the referee takes objection when the boxers try to enter the ring without boxing gloves, skull guard, then appropriate shoes, etc. Similarly, when one of the boxers falls down due to the blow given by the opponent, the referee counts for 10 seconds, and if the boxer doesn't get up to resume his fight, the referee would declare the opponent as the victor. Passing a decree ex parte or dismissal of a suit for default are also compatible with a referee's role. So with the above role of the judge as an umpire in our mind, let us show how a judge can pronounce judgment at once as mandated by law by taking some concrete examples. Suppose a suit based on a promissory note is being argued. Only two issues are framed, which are: 1. Whether the execution of the suit promissory note is true, and 2. Whether the suit promissory note, if true, is not supported by consideration. The plaintiff's advocate should argue briefly that the PWs 1, 2 and 3, who are the plaintiff and the two attesters, have consistently deposed about the execution of the promissory note. If the plaintiff's advocate tries to waste the time of the court by reading the entire depositions, the judge should immediately curtail him, saying, "Mr. Advocate, confine yourself to the consistency of evidence of the witnesses of the plaintiff without reading the entire depositions unnecessarily." Once the advocate briefly states the gist of the evidence of the witnesses, saying, "Your Honor, plaintiff's witnesses have consistently spoken about the due execution of the promissory note," the judge may note briefly in his notes paper that PWs have spoken consistently about execution. He must then ask the defendant's counsel to reply to the plaintiff's submission. If the defendant's advocate does not contradict this or bring out the inconsistencies or deficiencies of the plaintiff's advocate's submissions, the judge need not, and I dare say, should not read the entire evidence led by the plaintiff. He can instantly, that is at once, as prescribed by law, conclude that the execution of the promissory note is proved, as the defendant did not point out the inconsistencies on this issue. On the contrary, if the defendant's advocate tries to blow out of proportion the contradictions in the versions of the witnesses of the plaintiff, such as, "Your Honor, PW1 deposed that the promissory note was executed at 10 a.m. and PW2, who is the attester, deposed that the time of execution was 5 p.m. Or, "Your Honor, PW1 deposed that one and the same pen were used by him as well as the witnesses, whereas PWs 2 and 3 deposed that they used different pens for signing, and the witnesses were deposing after a gap of some 5 years from the actual date of execution of the promissory note." The judge is entitled to draw a presumption under section 114 of the Evidence Act and ask the defendant's advocate, "Mr. Advocate, how do you expect the witnesses to remember such minute details half a decade after the execution of the promissory note?" When the defendant's advocate fumbles to give an answer, the judge may note down that no satisfactory explanation was given. He can instantly come to the conclusion on this issue that the execution of the promissory note is proved. Then issue number 2. Once the execution is proved, there is a presumption under the Negotiable Instruments Act that the promissory note is supported by consideration. Therefore, the judge should turn to the defendant's advocate and ask him to show what evidence he has let in to rebut the said statutory presumption. If the defendant's advocate is able to show that even prior to the execution of the promissory note, the very same plaintiff had filed several other suits for recovery of money against the very same defendant, it would be a strong circumstance to show that the plaintiff would not have lent money to the defendant. At that stage, the judge should turn to the plaintiff's advocate and ask him as to how his client lent the money to the very same defendant who had already a history of defaults in repayment of debts to the same plaintiff, resulting in filing suits against him. If the plaintiff's advocate fumbles, the judge can instantly come to a conclusion that this circumstance is sufficient to rebut the presumption of consideration. This is only illustrative of the methodology to come to instant conclusions, though the actual conclusions might be different depending upon the facts of the case and the psychology of the judge. To avoid a gamble on the psychology of the judge, Advanced countries have already have entrusted the power of judging facts to a jury instead of a judge, as I already spoke about it. We may take a long time to reintroduce jury system in India, which was abolished in the 1960s, citing Commander Nanavati's case as the only reason. With such instantaneous conclusions, the judge can dictate the judgment then and there as mandated by Order 20 CPC. He can do it on the bench itself. Of course, the above is a simple illustration, but in more and more complicated cases, the judge is entitled to reserve the matter for judgment. But in most cases, he should pronounce judgment within 30 days as mandated by law. I repeat, the judge is not expected to read the entire case record himself, as it would unnecessarily overburden him, cause fatigue, delay judgments, and ultimately result in coming to wrong conclusions. When a driver, due to excess work, due to constant driving, he comes to wrong conclusions. Instead of pressing the brake, he presses the accelerator, and there is a collision. The same thing happened to a judge also. I repeat, the judge is not expected to read the entire case record himself, as it would unnecessarily overburden him, cause fatigue, delay judgments, and ultimately result in coming to wrong conclusions. Similarly, when the plaintiff's advocate cites a ruling of the Honorable Supreme Court on a particular point, the judge should note down the ratio decidendi only, and immediately turn to the defendant's advocate to show why the citation of the plaintiff should not be followed by the court. Mr. Advocate, is the citation irrelevant? If so, how? Is it overruled or per incurium? And if so, how? If the defendant's advocate does not give a clear-cut answer, the judge may immediately conclude that the plaintiff's citation is applicable to the facts of the case. It is impossible for a judge, nor is it expected of a judge, to go through all the citations from the first page to the last page to find out whether they are relevant or not. It is the advocates appearing for both the parties to point out how those citations are irrelevant or misquoted. The basis for the conclusion, I repeat, the basis for the conclusion is the representation by the counsel who are responsible officers of the court, and not personal verification of nook and corner of the case by the judge. The judge must extract the maximum amount of data from the counsel by putting the appropriate questions while hearing the argument. The same thing applies while construing documents. The judge should be an active participant and not a mere press reporter to note down whatever is argued by the advocates, however irrelevant it might be. In the Supreme Court and probably in the High Courts, this procedure is being followed to a greater or lesser extent, depending upon the efficiency of the judges. But in the trial courts, where most of the litigation is handled, no judge is following this procedure for fear of offending the advocates and inviting complaint petitions. This is resulting in immense wastage of time and effort on the part of the judge and other advocates who are waiting for their cases to be taken up. Now let me go back to the second issue as to whether the suit promissory note is not supported by consideration. The onus of rebutting the presumption of consideration is on the defendant. The defendant's advocate should be in a position to demonstrate how the presumption stands rebutted by referring to the relevant portion in the record. The judge should control the defendant's advocate. This is important. If he tries to beat about the bush instead of precisely pointing out the relevant material on record, if he fails to do that, the judge must at once conclude that the defendant was unable to rebut the said presumption of consideration. This can be illustrated by giving an example of a physical balance. The judge should initially, suppose this is the balance, the judge should initially start with his mind like a level balance. When the plaintiff goes on adding evidential weights in the form of exhibits and circumstantial evidence, apart from the admissions of the opponent, the balance will tilt on the side of the plaintiff. When the defendant starts putting his evidential weights in the pan on the balance on the other side, and if the evidence is relevant, the balance would slowly tilt in the opposite direction. Whichever side places greater evidence would result in tilting the balance on that side. When there are statutory presumptions, the judge should simply obey those laws by tilting the balance in support of the party who enjoys the benefit of the presumption, and expect the opponent to let in sufficient evidence to tilt the balance, putting appropriate weight. Such intensive grilling of the advocates by the judge is rarely seen in the lower courts these days. Why, I should say, it is never seen. If the counsel deliberately makes wrong statements of fact after warning him for the first time, a report may be sent to the local bar station for the second time so that the professional colleagues can suitably advise such advocates to mend their ways. He can be proceeded against for contempt by sending a report to the High Court if the advocate does not change his behavior. Complaint also can be given to the Bar Council to discipline such advocates. Why should all these things be done? Because when the council deliberately makes a wrong statement of fact, the judge depends upon the statements of the advocates. He is not expected to verify nook and corner of the judge of the record. So when an advocate deliberately does it, not by mistake, deliberately if he does it, this is the procedure. First, complaint to the local bar association, where the colleagues can only advise him. They have no jurisdiction to discipline him. Second time, if he repeats, send a complaint to the Bar Council and also to the High Court to take action for contempt. There are advocates who, due to lack of proper skills of presentation, tend to go on arguing matters on immaterial issues. There are also advocates who, knowing full well that they are beating about the bush, deliberately advance lengthy arguments and cite mostly irrelevant decisions of the High Court and the Supreme Court just to demonstrate to their clients that they have put in a lot of effort in fighting for their clients. The poor judge, especially in the subordinate judiciary, has to patiently hear and note down mostly irrelevant points, resulting in tremendous strain on his mind, apart from leading to wastage of precious time of the court. In the Supreme Court and probably in the High Courts, judges are able to restrict the time taken for arguments. In the trial court, the judicial officers do not have the necessary experience or the courage to control the bar. This video is intended to properly train them in this direction. What happens when the judge omits to notice some important aspects of the case by such hurried hearing? If such expeditious hearing results in injustice due to the possibility of the judge not noticing vital material, both of facts and of law, there is an expeditious remedy called review under Order 47 Civil Procedure Code. The traditional view that reviews can be entertained only in exceptional cases when there is an error apparent on the face of the record, used to discourage advocates from using this provision, and routinely advocates have been suggesting appeals to higher forum. This results in appellate courts getting flooded with appeals. Therefore, the Honorable Supreme Court has liberalized the requirements for entertaining reviews. In Daman Singh versus State of Punjab, please note this ruling, it's very important. The citation is Laws, LAWS Laws, Supreme Court 1985-4-40. It's a constitution bench of 5 judges. It was laid down that time of the appellate courts is not to be wasted in determining whether lower court failed to consider a certain point raised by the parties, and review in the same court is the proper remedy. This was also followed in another ruling which is reported in Laws, LAWS Laws, Supreme Court 2007-12-25. The next question is how to avoid delays in the execution of decrees. The Honorable Supreme Court laid down in a decision reported in AIR 2021, Supreme Court, page 2061, that execution petitions should be disposed of in 6 months. In money suits, even oral applications for execution are to be entertained. The court may initially grant 3 days time for filing counter in money EPs, where the defense would invariably be the JD has no means to pay, which does not require effort on the part of the judgment debtor to gain access to any documents. The decree holder, if he were intelligent and diligent, would be ready with the documents to prove the means even by the time of filing of the execution petition. If he is not diligent, court may grant 1 month's time to enable him to secure copies of documents. After the amendment of the Civil Procedure Code in 1976, the discretion of the court to grant installments after the decree is curtailed by Order 20, Rule 11, Sub-Rule 2, and unless the decree holder consents, installments cannot be granted. No doubt there was a state amendment in Andhra Pradesh and Madras deleting the requirement of consent of decree holder, but the same was held to be void as it was opposed to the Central Act in a judgment of the AP High Court in Kalvaram Reddy versus Sriram Chits in CRP 2067/2004. Dated 6/7/2004. In spite of the above amendment, courts are adjourning sales or releasing the judgment debtors from custody even if small payments are made by the JDs, thereby converting the decrees into installment decrees without the consent of the decree holder. This misplaced sympathy has made the above amended provision ineffective. Judges have no discretion to violate the mandatory provisions of law. It amounts to derailing the judicial train from the legal track. Procedure in conducting sales. After amendment of the CPC in the year 1976, as per Order 21, Rule 66, there is no need for the court to mention its own valuation in the sale proclamation. In spite of this, the courts are ordering the so-called tests to determine the market value. It is enough if the court mentions the value assessed by the decree holder and the judgment debtor in the proclamation. Upset price. A division bench decision of the Andhra Pradesh High Court has categorically laid down that the practice of fixing upset price by the court is deprecated as it is unworkable and leads to anomalies. This is reported in 1972 Andhra Law Times 52 and 2004-5 Andhra Legal Decisions, page 27, Notes of Cases, number 371. Many advocates are not citing the judgment at the appropriate time, and even where it is cited, courts are showing scant respect to such binding precedents. This is adding to the woes of the decree holder. Now, I must state that there is a judgment of the Honorable Supreme Court reported in AIR 1972, Supreme Court 2466, that if a judge doesn't follow a binding precedent, it amounts to contempt and misconduct. I'll speak about this in a greater detail in another topic. However, what is happening in the judiciary, everybody should know. No doubt, there is a ruling of the Honorable Supreme Court reported in AIR 1997, Supreme Court 938, which says that court must fix upset price, but that was rendered while interpreting rules framed by the Madras High Court and has no application in the state of Andhra Pradesh. It is advisable that the AP High Court may issue circulars directing the lower courts to dispense with the procedure of fixing upset price. Only when a mortgagee wants to participate in the bid, the court has to fix a minimum reserve price below which he shall not bid, as per Rule 72A of Order 21. This is not upset price, as third-party bidders are not bound by it. It must be borne in mind that the executing court has no power to secure any fair market price for the property unless a tribunal under the Land Acquisition Act, unlike a tribunal under the Land Acquisition Act, the court can only arrange for the auction in public by following some minimum procedural safeguards to take care of the interests of the judgment debtor, bona fide bidders and rival creditors. The price that is obtained in the court hall, however low it might be, itself is the market price, as the court hall itself is a market. If the judgment debtor is serious about securing a proper price, he can always resort to Order 21, Rule 83 to sell the property privately by negotiation by seeking permission of the court, notwithstanding the attachment. If the judgment debtor remains ex parte, the court may at best adjourn the sale by not accepting the highest bid only once to try to secure a higher price. Fixing upset price or declining to grant permission for decree holder to bid will not help the cause of justice in any way. Unmindful of all this, courts are treating judgment debtors with kid gloves and permitting them to drag on the matters indefinitely. Order 21, Rule 58 and Rule 90 petitions. The next hurdle the decree holder has to cross is a petition to raise attachment filed by the third parties, called claim petitions, and petition to set aside sale on the grounds of misrepresentation and fraud. Order 21, Rule 58, Sub-Rule 1, Proviso B says the court shall refuse to entertain a claim petition if it is unnecessarily or designedly delayed, and the aggrieved can always file a petition under Rule 99 of Order 21 or a comprehensive suit to attack the sale if he is likely to be dispossessed. The bar of suit arises only when the petition is entertained and dismissed. If it is entertained, the court may grant not more than 15 days to enable the parties to secure copies of the title deeds and post the petition on a day-to-day basis till it is finally disposed of. Regarding the Rule 90 Order 21 petitions, that is to say, to set aside the sale on the ground that fraud was played, there are innumerable rulings to the effect that mere inadequacy of price is not a ground to set aside the sale. Such petitions also may be disposed of by posting them on a day-to-day basis. How should judges exercise control over advocates in the course of judicial proceedings? This is a very interesting and important topic. Once the new procedure, which is actually mandatory, is implemented, we may experience some teething troubles. The most important problem that we might encounter is how should the judges react when a representation is made that the senior advocate is on his legs in another court and the matter may be passed over. It is all right to show some accommodation for the advocates, but if they do not turn up for several hours or the whole day, what should the judges do? The problem was discussed by lawmakers long ago, and the parliament inserted the following provision in Order 17 CPC, which is extracted below. Rule 1.